Richmond for putting this together and for inviting me to be a part of it. A couple disclaimers. As with any area of the law, things change frequently, especially with assisted reproductive technology law and the statutes catching up with the Marriage Equality Act from several years back. So anything that I discuss may not be exactly relevant in a year from now. So, and then everybody's situation is unique, so it's just important to understand that something that I may discuss or talk about here, might not apply to everybody's situation. So I'm first going to discuss a little bit about the legal aspects of gestational carrier contract drafting. The most important thing to know is that the gestational carrier and the intended parent need to have separate legal representation. There's actually another wonderful attorney here, Anna Ernst, who also does assisted reproductive technology law, and we work together representing intended parents and gestational carriers. So the intended parents generally pay for the gestational carrier's legal fees. The negotiations really don't start until a gestational carrier has been chosen, and then after that, once you've chosen a gestational carrier, the first thing that's really handled is an insurance review to evaluate what the gestational carrier's policy will and won't cover as far as maternity benefits, if there's any exclusions listed relating to her acting as a gestational carrier. The insurance policy review can take some time because usually they're about 200 pages long, so you just have to go through the weeds and make sure there's nothing in there that could potentially prevent, the coverage for that. So some of the main issues to talk about or to think about before the drafting and just discuss with your gestational carrier is, are you on the same, playing at with for religious or abortion or selective reduction views? Are you, in the same ballpark for financial terms? In Virginia, you can't compensate a gestational carrier for her services. However, you can reimburse her for what they call reasonable medical and ancillary costs, which ends up being basically living expenses while she's pregnant with your child. You want to discuss methods of payment, how you're going to handle, reimbursing her monthly, the level of confidentiality you want to have in your contract, the communication that you're going to have during the pregnancy and after, and then if there's any restrictions that intended parent would want to place on a gestational carrier, maybe dietary restrictions or travel restrictions or anything like that. So after the insurance review and after you've negotiated, the contract is drawn up. Usually it's about 40 pages long. And then you proceed with, your assisted reproductive methods. So once conception occurs, you then have to do what's called a birth certificate amendment, and that can either be accomplished through just a simple administrative procedure or an order of parentage through the court or a step-parent adoption. So every situation is different with that. Legislation has just been passed, and it goes into effect July 1st, that has removed gender-specific language in the assisted reproductive technology statute. So the changes are likely to ease the process for many. The next type of agreement I want to discuss is what's called a non-donor parentage agreement. And that's used in conjunction with what they call reciprocal IVF or co-IVF or co-InvoCell, which Dr. Robin will discuss in detail. It's generally entered into by a same-sex female couple who plans to utilize the eggs of one partner and the uterus of the other partner. So both have an involvement in the actual pregnancy. So the main purpose for this is to protect the genetic parent from being viewed as just simply an egg donor. We don't want that to happen. The way the statute is written now, it basically says that she is an egg donor. But in Virginia right now, there's a presumption that the gestational mother, the one who gives birth, is the mother of the child. So as with the gestational carrier agreement, there's 2 steps. You do the initial contract drafting. Most times the parties are represented by the same attorney. Typical provisions, the main one is just setting out that the genetic mother is not acting as an egg donor. And they talk about medical decision making for the child, who's going to be the child's guardian should something happen to both of them, who's going to be present in the delivery room, and many other topics, but that one's not as long. So the second step, just like with the gestational carrier contract drafting, is an order of parentage, because while now you can be listed as the second parent on the birth certificate doesn't necessarily grant you legal rights. So it's important to have an order of parentage from the court that will recognize you legally as this other parent. So, also on July 1st, the statute has changed, so whereas it actually is going to recognize for married parties the second mother as a legal mother. So I'm still kind of going through the statute, yes, and trying to figure out if I think that this voids the necessity to have this type of agreement. I'm going back and forth with it. I think it's still a good idea to have the parentage agreement drafted because, let's say, for example, you move to a different state that their laws might not have caught up to, where we're at in Virginia. And there's a thing called full faith and credit, and the courts of another state must give, full faith and credit to a judicial decision of another state. So I think that it's still a good idea to have one drawn up. I'm still kind of weeding through the legislation, but so while it's not something that we ever want to discuss, couples do get divorced and legal issues do arise. So in order to prevent long litigation, it's just important to have these things taken care of. So that's all.